Encountering law enforcement can be a nerve-wracking situation, even if you've done nothing wrong. Imagine you've pulled over to safely deal with something in your vehicle, then have a police officer pull up behind you. Nothing to worry about, right? You've done nothing wrong. Then imagine after providing your driver's license, you're pulled out of your car, searched, handcuffed, and stuffed into the back of a police cruiser while the officer searches your vehicle from stem to stern, even though you've done nothing wrong. Now imagine after this harrowing abuse of power, the officer claims qualified immunity and asks the court to dismiss your case against him. That's what happened to Basil Soukaneh in Waterbury, Connecticut. The current state of the case is certainly worth looking into. So we'll do that next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach the rising generation to be free. I'm glad you could join me today. This story originated with actually a YouTuber I follow, a lady by the name of Liberty Doll. She covered this case and in brief, and it was interesting enough for me to look into it deeper. If you have an idea of a case you think I might be interested in looking at, please contact me through the website, constitutionstudy.com. There's an Ask a Question button. Just click that and ask if I'd cover the case, and I'll be more than happy to look into it. I'll talk more about the website and some other things at the end of the episode, but for now, I want to talk about this case out of Waterbury, Connecticut. Is legally carrying a firearm probable cause that you're committing a crime? An officer of the Waterbury, Connecticut Police Department used Mr. Soukaneh's legally possessed firearm as probable cause to detain him and to search his vehicle. Now, after Mr. Soukaneh filed a complaint in the U.S. District Court for Connecticut, the officer, Nicholas Andrzejewski, I know I'm mispronouncing it and I apologize, he asked to have the case dismissed because he, as a police officer, had qualified immunity. While the details of this case should disturb everyone, not just gun owners, the outcome so far should give us hope. I remember when I first started carrying a firearm. I thought everyone could see it and that every officer would give me a hard time about it. After I got used to carrying, though, I didn't think much about it anymore, which is probably how Basil Soukaneh felt before November 12, 2018. At approximately 8:43 p.m. on November 12, 2018, Basil Soukaneh stopped his car with the engine running on the side of the street in Waterbury, Connecticut. Soukaneh's iPhone GPS, located in a holder mounted to the car's dashboard, was frozen, and he stopped his car to fix it. Here we have a responsible driver. He's having problems with his phone, and rather than trying to fix it while he's driving, he pulls over. Unfortunately, where he pulled over may have started his encounter with the law. The area was dark and known as a high crime area, well known for prostitution, drug transactions, and other criminal activity. Within seconds after Soukaneh stopped his car, Officer Nicholas Andrzejewski approached the vehicle, knocked on the driver's side window, and, according to Soukaneh, loudly demanded Soukaneh's driver's license. Okay, unsavory part of town or not, it's not uncommon for an officer to pull over to check on a possible driver in distress. There are many reasons for the officer to loudly demand Soukaneh's driver's license, but it should not be a problem, right? After all, Soukaneh has done nothing wrong, only pulled over to deal with a slight technical problem. The interior vehicle light was on, so although the area was dark, Andrzejewski could see the activity inside the car when he approached the window. As Soukaneh complied and handed his license over, he also provided Andrzejewski with his facially valid firearms permit. While doing so, Soukaneh also disclosed to Andrzejewski that, per the permit, he was in lawful possession of a pistol that was located in the driver's side door compartment. So far, Soukaneh is doing things by the book, especially for a person carrying a firearm. He has the interior light on so the officer can see. He hands over his driver's license along with his firearms permit and informs the officer that he also is in lawful possession of a firearm, including where it was at the time. Following that exchange, Andruski ordered Soukaneh out of the vehicle. According to Soukaneh's description, Andruski then violently dragged him out of the car, pushed him to the ground, yelled and screamed at him, handcuffed him, and pat searched his person, recovering neither a weapon nor contraband. Here's where things start going wrong. Officer Andruski has no reason to be concerned for his safety, since Mr. Soukaneh is being compliant with his commands. Instead, Officer Andruski is treating Mr. Soukaneh as if he caught a felon in the act of committing a crime. Still, Officer Andruski didn't stop there. Andruski then shoved Soukaneh into the rear area of Andruski's police cruiser and left Soukaneh bent over and partially on the floor of the vehicle. Soukaneh remained in that position, facing down and unable to see, until another police officer came along several minutes later and helped him sit up. I'm not familiar with the police guide in Waterbury, Connecticut, but I doubt it includes roughly handling a compliant detainee, much less leaving him in an awkward position while handcuffed and therefore unable to right himself. Once the other officer repositioned Soukaneh in the cruiser, Soukaneh saw Andruski search his entire car, both front and rear, as well as the car's trunk. After the search, Andruski returned to the cruiser and kept Soukaneh handcuffed and detained in it for an additional half hour, during which time a group of 7 to 10 police officers gathered. Even after searching Mr. Soukaneh and his vehicle, finding nothing by the way, Officer Andruski detains him for an additional half hour while additional officers gathered at the scene. You'd think Officer Andruski had captured a terrorist or other extremely dangerous person to draw such a crowd. At one point, Andruski began writing on his onboard computer and turned to a fellow officer who had arrived at the scene and asked him, "What should I write him up for?" The other officer laughed, and the sergeant, who had also since arrived, told Andruski what to write. All of this, and Officer Andruski did not even have an articulable crime to charge Mr. Soukaneh. However, the officer still wanted to write him up for doing nothing wrong. There was a footnote in the opinion saying that they were not even sure if a citation was even written for Mr. Soukaneh. Both parties agreed that at some point during Soukaneh's handcuffed detention while in the vehicle, Andruski ran a check on Soukaneh's firearm permit and confirmed that the permit was validly held. At some point in all this craziness then, apparently no one knows when, Officer Andruski did actually confirm that Mr. Soukaneh's firearm permit was valid. Soukaneh was subsequently released. Finally, after who knows how long, Mr. Soukaneh was released to go on his way. Now, many people would have just been happy to leave and not follow up. Thankfully, Mr. Soukaneh was not one of them. On July 25, 2019, Soukaneh filed a complaint in the United States District Court for the District of Connecticut. He principally alleged that Andruski's actions deprived him of his Fourth Amendment right to be free from unreasonable and warrantless arrest and/or detention, and warrantless and unreasonable search and seizure of his person, vehicle, and effects, and sought compensation and punitive damages pursuant to 42 U.S.C. sections 1983 and 1988. Now, so Mr. Soukaneh sued Officer Andruski under 2 federal laws. Under Section 1983, Civil Action for Deprivation of Rights, every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or the person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Section 1983 provides for people to file a civil case against anyone who, under color of law, deprives them of a right protected by the Constitution or laws of the United States. In the case of Section 1988, it appears to be more about collecting attorneys and expert fees. On December 31st, 2020, Andruski moved for partial summary judgment under Federal Rule of Civil Procedures 56A, arguing that his actions were justified because he had reasonable suspicion and probable cause, or alternatively, that he was entitled to qualified immunity as to the claims asserted against him because if any rights were violated, they were not clearly established. Officer Andruski asked for the district court to dismiss the case because, he argued, he was entitled to qualified immunity because he had reasonable suspicion and probable cause to treat Mr. Soukaneh as he had. On August 6, 2021, the district court granted Andruski's motion for summary judgment in part and denied it in part. The district court granted Andruski's motion for summary judgment with regards to the initial stop. It concluded that since Andruski's basis for stopping Soukaneh's vehicle was that the car was stopped at night in the roadway with the engine running in an area known for drugs and prostitution, it was reasonable for Andruski to believe that Soukaneh was committing a traffic violation, giving him reasonable suspicion to stop Soukaneh and check his driver's license and require him to step out of the car. If an officer sees a car stopped on the side of the road, especially in a part of town known for crime, is it reasonable to stop and ask the driver for his license? Yes. I'm not sure about having him step out of his car, though, but if the officer had simply patted Mr. Soukaneh down, I doubt this case would have been filed. After all, Soukaneh did hand over his license when asked, and even told Officer Andruski he was carrying. But what about the rest of the stop? However, the district court denied summary judgment on the remaining issues related to handcuffing and detaining Soukaneh in the police car, searching the interior of Soukaneh's car, and searching the car's trunk. The district court, however, was not willing to let Officer Andruski off on the search and seizure. The district court reasoned that Andruski did not possess the requisite arguable probable cause to justify this conduct, explaining that a reasonable officer would not believe that Soukaneh was committing a crime or possessed a meaningful threat of being armed and dangerous for merely disclosing the presence of a firearm and its accompanying permit. That was especially true in light of Soukaneh's compliant and non-threatening behavior, and the absence of any articulable reason for a defendant to believe the gun permit was counterfeit or otherwise invalid. Guess what? Legally possessing a firearm is not probable cause that you're armed and dangerous or that you are committing a crime. Remember, when Officer Andruski asked another officer, "What should I write him up for?" that should be a clue that you do not have probable cause that someone was committing a crime before you violated his rights. The district court pointed out just how absurd Andruski's claim was. The district court concluded that any contrary holding would make it practically impossible for the lawful owner of a firearm to maintain a Fourth Amendment right to privacy in his or her automobile. Accordingly, the district court determined that Andruski was not entitled to qualified immunity on these issues, and thus denied Andruski's motion for summary judgment in the remaining part. Not surprisingly, Officer Andruski appealed the court's decision. Before we go on, let's take some time and look at the court's explanation of qualified immunity. Qualified immunity shields officials when their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. This is based on White versus Pauley. The court has decided that government officers have some level of immunity from civil lawsuits. The qualification for such immunity is that their conduct does not violate clearly established rights protected by the constitutional laws of the United States. The problem we run into is who establishes what a reasonable person should know. The Supreme Court has instructed that qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officers from harassment, distraction, and liability when they perform their duties reasonably. This based on Vega versus Semple. Notice, it's not the Constitution or a law passed by Congress, but the Supreme Court that simply made up this qualified immunity because they thought it was necessary. It's an important principle of our legal system that law enforcement officers must have the necessary discretion to perform their required duties. The principle must be balanced, however, with a core tenet enshrined in the Fourth Amendment, the right to be free from unreasonable searches and seizures. Thus, it has long been the essential purpose of the prescription in the Fourth Amendment to impose a standard of reasonableness upon the exercise of discretion by law enforcement agents in order to safeguard the privacy and security of individuals against arbitrary invasions. This from Delaware versus Bruce. In other words, the actions of a law enforcement officer when conducting a search or seizure must be reasonable. Now, based on my research, the law defines reasonableness as what a reasonable person would find reasonable. See, I was taught you do not define a word by itself. Then again, I'm not a lawyer, thank God. Now, when Officer Andruski appealed the district court decision about summary judgment to the Second Circuit Court of Appeals, there were two main areas of the case the court needed to examine: Soukaneh's detention and the search of his person and vehicle. We start with the detention. Andruski first argues that he did not violate Soukaneh's constitutional rights by handcuffing him and detaining him in the police cruiser for over half an hour, because the detention should be governed by the standards set forth in Terry versus Ohio. And Andruski possessed reasonable suspicion of criminal activity to make a lawful Terry stop. Ah, the infamous Terry stop, or as it's colloquially known, stop and frisk. If you're asking yourself, but did Officer Andruski do more than just stop and frisk Mr. Soukaneh? You are correct. Alternatively, Andruski contends that even if the detention constituted an arrest, he possessed the requisite probable cause based on Soukaneh's possession of a gun, irrespective of the facially valid firearms permit. In other words, according to Officer Andruski, the legal possession of a firearm is probable cause for a person to be arrested. Apparently, to Officer Andruski, the legal possession of a firearm is itself a crime. Those aren't my words. They're the words of Officer Andruski in court filings. We disagree, however, that this was a Terry stop requiring only reasonable suspicion because the facts before us demonstrate that Soukaneh's detention was a de facto arrest for which probable cause was required but lacking. We further conclude that the detention violated Soukaneh's clearly established rights. Okay, the court disagrees that this was a Terry stop, which only requires reasonable suspicion of a criminal activity. I guess if the officer had run Soukaneh's license and firearm permit, found them valid and gone on his way, that would have been considered a Terry stop. That's not what Officer Andruski did. It has long been the law that an investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. A reasonable officer in Andruski's position who had desired to check the validity of an individual's licensing information would know that the circumstances here could barely justify a Terry stop, let alone a prolonged, handcuffed detention. Officer Andruski did not follow the law. This detention was more than temporary, lasting longer than necessary to check Mr. Soukaneh's credentials. By placing Mr. Soukaneh in handcuffs and roughly placing him in the police cruiser for an extended period of time, Mr. Andruski violated both the law and Mr. Soukaneh's rights. This is not a case in which there were circumstances, however insufficient, to establish probable cause. That might suggest to a reasonable officer that there was something illegal about a suspect's possession of a weapon. Here, there was literally no reason to believe that Soukaneh's possession of the gun, whose presence Soukaneh freely acknowledged, and for which he provided a facially valid permit that Andruski had no reason whatsoever to believe was forged or had been revoked, was unlawful. In short, it appears quite apparent by both the actions and words of Officer Andruski that he arrested Mr. Soukaneh for the alleged crime of legally possessing a firearm. However, the record here, taken in the light most favorable to Soukaneh, supports a finding that the detention continued far longer than was necessary to effectuate any of Andruski's alleged reasons for his actions, legitimate or not, demonstrating that he did not conduct the stop efficiently or in the least intrusive way possible. In absence of facts suggesting some irregularity to justify the nature of the detention, the constitutional question and the unreasonableness of Andruski's actions here are beyond debate for any reasonable officer in Andruski's position. Even if Officer Andruski's reasons for detaining Mr. Soukaneh were legitimate, by not using the least intrusive methods to assuage his concerns, he not only violated Mr. Soukaneh's rights, but did so in a manner that is beyond debate. Now, the other area of concern this court had was the searches, both of Mr. Soukaneh's vehicle and trunk. Andruski argues that there was no constitutional violation as to his search of the interior of Soukaneh's car because it was a lawful Terry frisk of a car. He further argues that the warrantless search of Soukaneh's trunk was lawful under the automobile exception to the warrant requirement. Officer Andruski claims that his search of the vehicle was legitimate because it was a Terry frisk of the car. However, as the court has pointed out, by the time Officer Andruski initiated his alleged Terry frisk of the car, he had already de facto arrested Mr. Soukaneh, having handcuffed him and placed him in the cruiser. And what about this automobile exception? Under the automobile exception, states may allow the warrantless search of an automobile except for the trunk if the police officer reasonably believes that the vehicle holds evidence of a crime. The U.S. Supreme Court has determined that this exception is not a violation of the Fourth Amendment because drivers have a reduced expectation of privacy and because a vehicle is inherently mobile. Notice that the automobile exception requires the officer to reasonably believe that the vehicle holds evidence of a crime. Yet nothing in what Mr. Soukaneh said or did, other than stopping in a bad neighborhood, provided any reason to believe the vehicle held evidence of a crime. Furthermore, the automobile exception specifically excludes the trunk. Not only was there no risk of the vehicle leaving the scene with evidence since the operator and only occupant was cuffed and detained in the officer's cruiser, the officer also detained Mr. Soukaneh for 30 minutes after conducting the search, in which there was plenty of time to call in for a warrant. However, we reject Andruski's contention that either of these searches were justified and that they did not violate clearly established rights. In addition to being necessary for Soukaneh's de facto arrest, probable cause was also needed for the warrantless searches of his car. As discussed above, no probable cause existed. So Officer Andruski had no reasonable suspicion that the car contained evidence and had no probable cause either to arrest Mr. Soukaneh or search his vehicle. The court notes there is another way Officer Andruski's search could be considered constitutional. However, another inquiry for determining the lawfulness of a vehicle search during a traffic stop is whether an officer had a reasonable apprehension of danger which may permit a Terry frisk of the automobile. Now, did Officer Andruski have a reasonable apprehension of danger? Andruski argues that the Supreme Court's holding in Michigan v. Long precludes us from finding that he violated Soukaneh's constitutional rights when he searched the interior of Soukaneh's car because of the known presence of a gun. Yes, there was a gun present. In fact, Mr. Soukaneh told the officer that he legally possessed a firearm, produced his permit to have the firearm, and even told him where it was in the car. But that wasn't good enough for Officer Andruski. However, a straightforward analysis of Long leads us to conclude that this is not correct. The presence of a lawful weapon alone does not automatically make someone suspicious, nor a situation dangerous, such as would justify the Terry frisk of a car. The lawful presence of a firearm alone does not make someone suspicious or dangerous. If that were true, every law enforcement officer would be considered suspicious and dangerous. Considering the actions not only of Officer Andruski, but of his fellow officers, including the sergeant, it is understandable why people are suspicious, not of legal gun owners, but of law enforcement. After all the bad things that happened to Mr. Soukaneh, this case is a glimpse of vindication for him. This is not a close call about which reasonable officers could differ. The law, as it stood at the time of the events in question, left no doubt that a person in possession of a firearm and a facially valid permit for that firearm had a clearly established right to be free for the kind of forcible and prolonged detention to which Soukaneh was subjected, absent any objective reason to suspect that the permit was forged or otherwise invalid. This wasn't even a close case. It's not like Officer Andruski made a judgment call supported by the law. Rather, he ignored the law, apparently assuming that a lawful gun owner was, by definition, suspicious and dangerous. That type of thinking is what got Mr. Andruski in trouble. For those reasons, we hold that Andruski's alleged conduct violated Soukaneh's constitutional right, where the detention constituted a de facto arrest without probable cause, and where case law from the Supreme Court and this circuit clearly established Soukaneh's right to be free from such detention under the circumstances. I agree with the court, but I would have gone one step further. Yes, Officer Andruski violated Mr. Soukaneh's rights protected by the Constitution of the United States. Officer Andruski's actions were not only reprehensible, but were criminal. So under 18 U.S.C. Section 242, we find, whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be fined under this title or imprisoned not more than 1 year or both. Mr. Andruski clearly deprived Mr. Soukaneh of rights protected by the Constitution and laws of the United States, and did so under color of law. Furthermore, since Officer Andruski allegedly roughly removed Mr. Soukaneh from his vehicle and tossed him in the back of his cruiser, it is quite possible that Mr. Soukaneh was injured by the illegal actions of the officer, triggering another part of Section 242. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosive, or fire shall be fined under this title or imprisoned not more than 10 years or both. It seems to me that Officer Andruski should face criminal charges for his actions, though that was not the question before the court. The question was, did the district court err by denying Officer Andruski's motion of summary judgment and dismissal under qualified immunity? Thankfully, not. For the foregoing reasons, we affirm the judgment of the district court and remand the case for further proceedings consistent with this opinion. That doesn't mean Mr. Soukaneh's ordeal is over. The decision merely means that the district court can proceed with Mr. Soukaneh's lawsuit based on the facts at hand. Mr. Soukaneh has a long way to go before he finds out if he will receive a favorable redress of his grievance. Even if Mr. Soukaneh wins his day in court, this does not mean that Officer Andruski will be personally punished for his crime. Since this is a civil lawsuit, the City of Waterbury, Connecticut will pay any judgments against Officer Andruski. Unless a criminal complaint is filed, there will be nothing to prevent Officer Andruski from doing this to other law-abiding citizens who are not only exercising their right to keep and bear arms, but complying with the unconstitutional and therefore invalid laws that Connecticut has put in place. If complying with the law is not enough to keep you from police harassment, how can we call ourselves a nation of laws, not of men? As I mentioned before, I first found out about this case on the Liberty Doll channel. And I thought, it's so outrageous, I have to find out the details. And when I got into the actual details, I was shocked. I was shocked by the actions of Officer Andruski. I was actually pleasantly surprised by the actions of Mr. Soukaneh. He did everything right, but he still suffered. But he also went on to sue. I hope there are plans to actually file a criminal complaint against Mr. Andruski. There may even be more than a Section 242 option on the table. My concern is, will Officer Andruski and other officers, not just in Waterbury, Connecticut, but around the country, will they learn the right lesson from this? That just because a person apparently is lawfully carrying a firearm, they are not automatically a criminal or even suspicious of being a criminal. Think of it this way. You have a right to remain silent. We've all heard the Miranda warnings on TV, right? Do you realize that under court structures, an attorney is not allowed to use your right to remain silent as an accusation of guilt? In other words, if you're in a court of law and you took you said, no, I'm exercising my right to remain silent, the opposing attorney can't say, well, you must be guilty of something. Why would you remain silent? That's actually an ethical violation. It's the same thing here. He followed the law. He was doing what was right. It was the officer was wrong. And the officer was wrong from the very beginning. My question is, where did the officer learn this? Was there training in Waterbury, Connecticut? What police training led him to believe that it was appropriate to take a facially valid permit, a facially legal owned firearm, and use that as probable cause to arrest and search an individual, to violate his rights so abusively? Where? This is an area where we need better education of law enforcement, or maybe Mr. Andruski just has a chip on his shoulder. I don't know. In either case, I would hope that the City of Waterbury, Connecticut might see this as an opportunity to say, maybe we need to train our police officers a little better. I still would hope so. I also hope that you'll consider supporting the work that we're doing here at the Constitution Study. Maybe going to the shop and picking up a book or two, or joining our Patriots program. You can also support us through your cell phone. Just go to patriotmobile.com/constitution, find a plan that works for you, and join. Get a new number, bring your old number. Best of all, if you use the code Constitution at checkout, you'll get free activation. So again, that's patriotmobile.com/constitution. Be sure to use the code Constitution at checkout. Most of all, I hope you come back and join us here the next time we get together for the Constitution Study.
Lovely neighbors and have a few